Thank you for joining another episode of Transitions. Today's topic, we'll be discussing why do you need a will or a trust? A will or a revocable living trust determine how your assets are distributed and who manages your affairs after death. This is especially important as if you're transitioning a business, such as a farm, to have a written plan as to what happens with those business assets and assets not related to the business as well. If you do not have a will or a revocable living trust that states your wishes, then the distribution of your assets upon your passing defaults to state law. Especially important for individuals with younger children, you need to ensure that your children are raised by someone you have chosen, so naming a guardian in that will or trust. You also need to ensure that your financial assets are managed by someone you trust, especially if your children are minors. And then also, it is important to have this plan in place to have the proper tools to control your estate taxes. The main differences between a will and a revocable living trust are outlined here. First off, a will goes through probate. Probate is the legal process of settling your estate and is often court supervised. A will cannot control or own assets. They are owned individually by you and look towards your will for guidance as to what happens to them. From an expense standpoint, wills tend to be a little less expensive to draft on the front end, but some of the work that's involved in the probate process could get costly. A will could have a trust built into it that spins off upon your passing, and then that trust could control your assets for a certain period of time. You can amend and alter a will at any time and replace your old will with a new one. And a will is administered by a personal representative. That's the individual that gathers the assets and distributes per your wishes that are in writing. The revocable living trust can avoid probate if properly funded. So an important part of funding a revocable living trust is titling the assets in the name of the trust, such as real estate. You want to own the land in the name of the revocable living trust so that it is controlled by the disposition of that trust document. For this reason, settlement is a little bit more private because trust documents are not generally filed with the court system, and the trustee can step in and handle the disposition of the trust upon your passing. They can be more expensive to set up, mainly because of the retitling of assets and the detail that can be put into the trust document. Like I said before, that trust can control and own assets, so you can set it up to be ready for incapacity or death. That's the next point here, that a trust can become effective when you're incapacitated, unlike a will that only becomes effective upon passing. Much like a will, you can amend, alter, or cancel at any time. That's the revocability part of this trust. And rather than a personal representative, a trustee is responsible for the revocable living trust administration. Any questions, feel free to contact anyone on the succession and retirement team, or my information is here.